continue to be under oath.
I confirm, Chair.
Thank you, sir. Advocate Batohi,
Thank you, Madam Chair.
let's see how far we can go.
Yes, no, I think we will be quick this morning. I've taken up more than I deserve. Mr. Chauke, we had explored the Ketumano situation, I think to the extent that we could in the last 2 days of your testimony. So I want to shift the focus to the matter of Lieutenant General Mdluli, which you've already testified about and you've explained what your defense is, namely that there is a binding SCA judgment on the matter and that there's no basis to overturn that. But I just want you to look at the charge or the terms of reference again and then to close that issue. It's 3.1.2.
Yes, I'm there, Chair.
So the way is formulated says that the failure to continue with charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Therefore Abel Ramokhebe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Therefore Abel Ramokhebe and related charges to be withdrawn, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, which decision caused a significant delay in proceeding with the charges concerned. So presumably when they say his involvement, they mean his alleged involvement, because his involvement was never actually established.
Indeed.
And then the next thing is this idea of causing the charge of murder to be withdrawn. What does that mean?
It means that when I withdraw the murder charge and refer it to the inquest.
Yes, all right. And then it says, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter. So I think that's where the mistake is against you. That's what you are being criticized for.
There was a strong case in respect of the murder charge, which is wrong.
Precisely, but that's what they are saying.
Yes.
Yes. And then there's also, I think there's a second issue they're taking up with you, which is that your decision caused a significant delay in proceeding with the charges concerned. I presume that means, there was confusion in the evidence of Advocate Batohi about what this part refers to, whether it refers to the murder charge or it refers to the other charges, the 17 other charges. Like where was the delay?
Yes, I heard when she testified.
Yes. But we shall presume here that the alleged delay cannot be on the murder charges because there can be no delay there. That was closed up.
Yes.
So it can only be the delay in the other charges.
Yes.
All right. But that's also fully dealt with in the SCA judgment.
Indeed.
Yes. So when they say charges concerned, they mean the 17 charges.
I presume so.
Yes. So therefore, the scope of the charge, it seems, would be you referred the murder to an inquest. That's number one, and they say that's wrong because there was good evidence, strong evidence. The second one is that you caused a delay in the 17 other charges. Would that be your understanding?
Yes.
All right. Now let's deal then with the first one. As I understand on Advocate Batohi's version, what she read here, according to her, was the opinion of Advocate Hali.
Yes.
And what Advocate Hali in turn read was a statement by Captain Rulufse?
Lieutenant Rulufse.
Lieutenant Rulufse, which was given in the bail application.
Yes.
and nothing in the actual investigation of the murder.
That's my understanding from reading that opinion.
Yes. I mean, well, it's now common cause. I mean, that's why I'm happy to tell you, because it's established on the record that the one read an opinion, the opinion read another opinion. Yes. And by contrast, what did you actually read?
I read the statement in the case docket, as well as the prosecution memorandum and the representations that were made on behalf of General Mdluli.
Well, if you look back at the document we circulated at the commencement of your evidence, which is a list of annexures to the witness statement, which listed everything you read in Cato Manor and everything you read in the Lieutenant General Mdluli case.
Yes.
Can you just take us to page 6?
I'm there, Chair.
And then take us through what you read in contrast to Advocate Harley, who read one document, and Advocate Batoi, who read the opinion that read one document.
Thank you, Chair. The first one is the affidavit of Michael Ramokhibe, which is on record VR 00553 to VR 000554. The statement, the second statement of Abel Ramokhibe, which is at VR 000028 to VR 000030. The affidavit of Lena Ntsekiseng Ramokhibe Mbuyisa, VR 000071 to VR 000073. A statement of Abel Ramokhibe prior to being shot is VR 000487 to VR 000488. Then the affidavit by Detective Sergeant Zelindawo Samuel Gomo, which is at VR 000546 to VR 000548. The affidavit by Ms. Malitsatsi Sophia Ramokhibe, that is the mother of Mr. Ramokhibe, VR 000042 to VR 000046. And the affidavit by Ms. Malitsatsi Sophia Ramokhibe, mother, which was written in Afrikaans, VR 00527, VR 00529. A postmortem report at VR 000108 to VR 000111. A statement by Consolation CD Modise, Buthelezi, dated 2nd March 1999 at VR 000555 to VR 000557. Statement by Alice Manana, VR 000001 to VR 000010. Affidavit by Mohau Johannes Ramokhibe, VR 000047 to VR 000058. J88 medical legal report, VR 000022 to VR 000027. Statement by Johannes Christian Duplessis, VR 000097 to VR 000104. Statement by Manyatela, VR 000193 to VR 000195. Affidavit by Lieutenant General Sitwanso Godfrey Libya, VR 000319 to VR 000321. A statement by Timba, VR 000445 and 00171 to VR 00173. Affidavit by Lieutenant Godfrey Sitwanso Libya, VR 00322 to VR 000325. statement by investigating officer, rule of law opposing bail, VR 00748 to, RM 0078 to RM 0084814 and VR 000326 to VR 000430.
Yes, if you could just stop there. This is the statement that was read by Mr. Harley,
Yes,
the only statement he read from this document.
that's how I understand it.
It's not clear from his opinion whether he had access to the docket or not, but that's the statement he read. Now, what struck me was that this is a statement in the bail proceedings. It's not even a statement in the main case.
Yes,
And did Mr. Rulufse give another statement in the main case?
yes,
He did.
he did. That is the one that is recorded as VR 000326 to VR 000430.
Yes. So he gave two statements.
Yes.
Yes, all right. All right. It's unclear then why.
And the one that, if I may,
Yes.
the one that Advocate Halley relied upon is which one of the two?
The one the RM 00748 to RM 00814. That's how I understand it.
Yes.
Thank you.
We will just confirm that, Madam Chair. Now, I've asked Mr. Ramukhale to do that job. Then continue. This is now a second statement of. Well, it's the third, if I'm not. No. It's actually a
It's one and the
repetition.
same thing.
Yeah.
I just made a mistake. I repeated.
Yes, it's the same thing. So we can scratch that one because it's referred to in the second column.
Yes.
All right. And then carry on.
Statement by supplementary by Mdluli, which is VR 000453. And then affidavit by Tembele Mtunzi, VR 000458 to VR 000473.
Okay, Toby. The statement of Lieutenant General Lebeya, the one that you have just read, is it the same statement as the previous one because the dates are different?
Madam Chair, I'm comparing it with the one at which is in the second column of the same page.
The same page 8.
Yes.
Oh, yes.
So it looks like he gave two statements, not three.
Thank you.
Yes.
So we must scratch the second one.
Yes.
Thank you, Proceed.
Yes. Thank you.
And a statement by Area Commissioner Leonard Anthony van Tonder at VR 000579 to VR 000581.
Now, before you proceed, I just want to, because I just want to confirm something around the statement of Mr. Rulofse, because it's the pivotal statement that became the it's just this one. It's not up to the one that's left. Yes. So let's just get some detail out of this just to go back to the issue of Mr. Rulofse, because I'm not sure if I understand precisely what's going on, and I just don't want to leave the panel as confused as I am. So the first document is the opinion from Mr. Harley and Ms. Wenzel, and that's dated, well, she's now Judge Wenzel, and that's dated LO 001047.
It's a LO
So LO 001047.
10.
No, 1047, yes.
Volume 4 of the legal opinions.
Thank you, Madam Chair.
Yeah, thanks, Chair. On there?
So do you have this is the opinion of Mr. Harley and Ms. Wenzel, correct?
Yes.
Now, the reason I say that it's common cause that they relied on the affidavit, it is paragraph 5 of that opinion.
Yes, paragraph 5 reads, before delving into our process of reasoning and the evidence to support that reasoning, there are primary facts and observations.
Preliminary facts.
Preliminary facts and observations we should set out to better understand what is to follow. These are all derived from the affidavit of Colonel Kobus Dimer Rulofse, who had investigated the charges against Lieutenant General Mluli. We attach a copy marked A.
Yes, now the problem is that when the NPA gave us this, they didn't give us Annex A itself, what it says. But anyway, the fact that that's the only thing they read is clear from that report, from that opinion, because they never explain what is the other source of their information.
Yes.
But it's clear that they relied only on Mr. Rulofse's affidavit.
Yes.
Now, that we have to find it somewhere else, the affidavit. We find the affidavit at in another section. Yes, in the Mdluli docket, what we find in RM 00010, which is under RM1.
It's a page.
So the document I have here is RM 00010. Got that.
Report 010.
Yes.
Yes, on there, Chair.
Yes. Now, if you look at that, that is an answering affidavit by Kobus Dimer Rulofse.
Yes.
Yes. And the reason he submits that is to oppose a bail application by Mr. Mdluli, correct?
Yes.
Yes. So that's one candidate about what that Annex A is about. And the grounds for opposing the bail would be at RM 00029.
I'm there.
Yes. And that's where he talks about the strength of the case at RM 00030. That in his opinion, the case is very strong. Can you see that?
Yes, I see that.
Yes. So that's one potential candidate about what Annexure A is, but we still don't know. And then there is another document also signed by Mr. Kobus Dimeya Rulufse, which is under RM 00748. RM3.
It's 4
So that's his
007.
48.
Yeah, yes.
Now, that is another statement. I'm not sure if it's an affidavit or a statement. But what caught my attention is that in paragraph 3 thereof, he says he has deposed to 2 affidavits dated 11 April 2011 and 12 April 2011. Can you see that?
Yes.
And the one we just looked at, it seems to be the one of the 11th of April and not the one of the 12th of April. So the one we looked at RM 00010.
It's 11 April. The one that we looked at.
Yeah, so that's the 11th of April if you look at
Yes.
RM 00047.
Yes.
Yes. And then the 12th of April, I'm not sure where that is. And so when you look at Annexure A, it is utterly confusing about which of those 3 affidavits Mr. Hale read.
Yes.
Yes. Now, this is where the problem then becomes, is that when you see Advocate Batoyi, who is the person that must make a rational decision to charge you, saying, I've relied on Mr. Hale's affidavit. And then, on Mr. Hale's opinion, when you look at the opinion, it talks about Annexure A, it doesn't attach Annexure A. You try and find out from the record, you find 3 different documents, and you can't work out what are they talking about.
I agree.
Yes. Regrettably, Advocate Batoyi left this chamber before we could cross-examine her on this point.
Yes.
Yes. All right. I needed to clarify that when we are talking about Mr. Rulufse, that we are actually talking 3 different statements, and we can't work out which statement was read and relied upon by, well, we know for sure that there is no statement read by Advocate Batoyi, but we can't work out which statement was read by Mr. Hale.
Yes.
Yes. Unfortunately, she can't testify. He's an advocate. He can't testify here, so we would just never know.
Yeah, we can just assume which one statement and take it from there.
But we can't make assumptions. Yeah. This is your career at stake. There has to be proof. Now, you've dealt with the supplementary affidavit of Mr. Mdluli, and there is also Mtunzi, Omche, and
Yeah.
Tembeni Mtuzi.
Okay.
Okay, carry on.
The other statement is a statement of Major General Harold Godfrey Engelbrecht in VR 000608, VR 000614. And the state,
In relation to, sorry, Council, in relation to the statement of Mr. Mdluli's written statement by supplementary, does it mean that this statement was supplementing a previous statement by Mr. Mdluli?
yes, when he was at the bail hearing.
Where is that statement in the list? Because I see the supplementary statement, the one
I,
on page 8.
yeah, the statement, I'm not so sure on record what is it, but it's marked A53 in the case docket. And here I see it's V000453 VR.
And this one is a supplementary affidavit statement.
Yes.
And the initial one, what is it marked in the record? We can search later.
I'll try and search, but the supplementary affidavit is the one that was written by hand. It's not typed.
I think the question by the chair is in the docket, where is the first statement that is being supplemented? I think that's really the question. So
Yes.
we must just try and find that.
I'll find out. It was supplementing the affidavit that he made in the bail application.
Oh, I see.
I'll
So if we
trace it.
find that affidavit.
Yes.
So we've got that.
It does not appear in the list. Where is it appearing in this list?
I omitted to list it on the list, Madam Chair. My apologies.
Yeah, we understand. We'll get the reference number of that statement.
Yes.
Perhaps Mr. Ramokhali can locate
Yes, I have no doubt.
a place in the record where we can find the main statement.
Yeah. Thank you, Madam Chair. We shall make sure. But Mr. Chauke, you are saying that was a handwritten supplementary to the application in the bail proceedings.
Yes.
All right. Well, that should be easy to locate. All right. Carry on then. Following page 9.
A statement by Deputy Provincial Commissioner Benning Tanderson Lemeza at VR 000831 to VR 000846. And statement by Lieutenant Colonel Peter Jansen Viljoen at VR 00932 to VR 000934. And representations by Mdluli at RM 00338 to RM 00355. The prosecution memorandum regarding representations by Advocate Van Sale and the two others, Galega and Advocate Barnard, the RM 00881. I just did not take the last page there. I omitted to record how many pages are there. Inquest report, which is at RM 00889. And the inquest findings by magistrate at RM 01002 to RM 01044.
Yes. Now, what seems to have become, look, there's quite a lot of documents in this docket.
Yes.
Quite a lot of things that you read,
Yeah.
and you came to your conclusions. Now, what it seems, and I'm speculating here because we were denied a chance to cross-examine the complainant by her walkout, is that if you look at the item referenced as prosecution memorandum, we can go through that. It's RM 00881. Maybe let's just do that rather than. It's RM 00881. I think we can say that. Let us know when you have it.
Uh, 00881.
Yes, yes, yes. It would be under RM4.
Yeah. It ends at RM 00884.
Yes, all right. No, that's fine. But I'm interested in where it starts, RM 00881.
Yes, I'm there.
Yes. Now, there were many occasions when Advocate Batoy said, well, the prosecutor said that there's a good case on murder. You remember that?
Yes.
Now, the only time I can find in this record is that reference is this document, this 4-page document, RM 00881. And that is a response to the representations that were made by Lieutenant General Mdluli.
Yes.
He raised a lot of things about a conspiracy against him, etc.
Yes.
But the analysis around the strength of the case of the state, you'll find that at RM 00883 under issue 2.
Yes.
Yes. Now, item 1, they say the case on the murder charge relies solely on circumstantial evidence. Those include a threat by the accused to the deceased family that the deceased will be killed. 2, the state has direct evidence linking the accused to kidnapping, assault with intent to do grievous bodily harm and intimidation. And 3, all this evidence is of incidents that took place prior to the murder of the deceased and are in relation to the love triangle involving the deceased and General Mdluli. We have consulted with all of these witnesses extensively and hold the view that their evidence constitutes prima facie proof of these crimes. Paragraph 4, the attempted murder charge, count 13 and 14, are also based on circumstantial evidence. 5, the overall picture painted by this evidence is that of a thwarted lover who was hounding the new love of his girlfriend and who would stop at nothing to get rid of his fellow suitor. And 6, the charge of defeating or obstructing the course of justice encompasses the whole history of the further confirmed by the fact that two dockets implicating him in this matter were discovered in his safe.
Yes.
Now, there is nothing else that I could say from this memorandum that analyzes the underlying evidence in detail. I looked at the prosecution memorandum that people like Advocate Mayema did for Kato Man, and I saw the detail at which they were going through, analyzing each witness, the weaknesses on each witness, the strengths on each witness. the likely questions from the bench, the likely attacks from the other side, and it went on to more than 100 pages. But here I found only 6 paragraphs and no more than that. Did you find anything else other than these cryptic paragraphs?
You meant from the
Yes.
prosecution memorandum?
Yes.
No, that's what was there in the prosecution memorandum.
Now-
I had to interface with it against the evidence, which
I understand. I'll deal with that. But I just want to know if there was anything else that emanated from them other than these 6 cryptic paragraphs.
no.
Yes. Now, when Advocate Batoyi repeatedly talks about the prosecution memorandum that outlined that there was a strong case, she never actually went through the prosecution memorandum herself on her own version.
Yes.
She just heard from someone that there was a prosecution memorandum. And she never took the panel to the contents of the prosecution memorandum.
Yes.
Yes. Now, and when you look at the prosecution memorandum, it actually doesn't analyze the evidence. At least the only comparative analysis we have here is the Miami dossier
Yes.
that actually shows you how this is done. Now, so then you have these 6 cryptic paragraphs that basically say, look, we admit that the case is circumstantial, but we think it's strong.
Yes.
Yes. What then did you do after you received this?
But only in relation to the murder
To the murder, yes.
and attempted murder.
Yes, yes. Murder and attempted murder, yes. But the other, they say it's direct. Well, yes, that's correct, Madam Chair.
After that, Chair, I called for the case docket
Yes.
to be placed before me so that I can read the case docket as against their submission and the representations which came from General Mdluli.
And why do you call for the case docket? You see, because we've got a strange thing here where the NDPP takes a decision of monumental proportions. She's never read a single docket.
Now, I needed to apprise myself so that the decision that I will make one way or another should be based on the facts and based on law.
Yes, yes. But I mean, did you feel that you couldn't make a decision as a decision maker without having read the underlying documents?
Indeed.
Yes. And then what happens thereafter?
No, I got the case docket. I went through all the statements and discovered that even on the summary of the prosecution memorandum, there is an omission in respect of the evidence relating to the death of Nkabinde, which they did not analyze it.
And what was that omission?
That after, when there was this assault and kidnappings and the like, there was a friendship that developed between Nkabinde and Kimba and Mthunzi. And even where Nkabinde borrowed the car from Kimba to go to Nelspruit and came back. And then even on the attempt that happened to him, firstly was he was driving that car of Kimba.
Yes.
And the notion that he was now always fighting, having problems with Kimba and Mdluli and them, to me that indicated that there's something more to that, and I understood why. Maybe the prosecutors would have omitted that, because that negates the theory that a jilted lover was now busy pursuing him, because these guys were also working with Mdluli at the police station at Fort Solaras. And even that attempted murder, it was reported to them, and this Dlomo was the investigating officer, and Mthunzi was also the one who took Abu Ramkheba to the police station to open the case of attempted murder.
Yes.
Yes.
And those omissions, why were they important for you?
The theory that we had developed to say he was killed by Mdluli because of his the love affair, that he was angry about it, and like, it's negated by the fact that there was now a relationship that developed between him and Mdluli's associates.
I see.
Yes.
After the
Yes. After the kidnappings, and then I got what it was almost about 2 or 3 months thereafter.
Yes.
Yes.
Now, you had, I suppose, how many choices did you have? 2 or 3 choices. You could simply go ahead with the prosecutors,
Yes.
or you could overturn them.
Yes.
And if you overturn them, you could have just withdrawn the charges, full stop.
Yeah, I couldn't they withdraw the charges. The other charges, Chair, there was strong direct evidence linking all the 3 of them to the commission of the offences. I could have just said withdraw the murder charge and proceed with the other charges, but that was not going to be practical in the sense of the theory that was created by the investigation team, which was given to the prosecution team.
Yes.
So I had to test that theory through the inquest where the evidence would have been tested, and that's exactly what happened.
Yes. Yes, that's the point, is that you could have withdrawn it.
Yes.
But your view was that an inquest would be better.
Yes.
And why?
To ventilate and investigate the theory, whether the theory that the investigating team is having and the prosecution team is supported by the evidence, because on the evidence that was my problem, that there was no link. The theory is a theory. It does not suggest that factually you will be in a position to prove that. And then even if you apply inferential reasoning, whether that will be the only inference that you can draw, that this Ramokheba was killed only because of the love affair that he had with Mndole's girlfriend.
Yes. What would be the benefit of an inquest?
The benefit of inquest, that theory was going to be to be determined, and witnesses were going to testify, and they will be subjected to questions from the magistrate and from the prosecution team and police attorneys.
And what if the prosecutors say, let's go to trial instead of an inquest? How do you explain that to them?
No, exactly what I did. This is the decisions that I have made. That you are recommending this. My view is this is what should happen. Ultimately, the decision to prosecute is the decision that must be made by the DPP, who was made at stage.
Yes, now I understand. But and what were the interactions, if any, between you and the prosecutors, Mr. Van Zyl and Mr. Barnard and Ms. Baleka?
No. We discussed. I showed them my reasoning, and they accepted my reasoning, and that's why I issued the instruction and then issued the request to the magistrate to do a formal inquest, and I listed these witnesses who were supposed to be examined at the inquest.
Because you see, we have this thing about the Ketomano where the NDPP just makes a decision, announces it publicly, has never engaged the prosecutors.
Yes.
And in your case, what did you do?
I engaged the prosecutors, like I indicated.
Yeah.
And it's even them who were leading the evidence at the inquest.
Yes.
Yes.
So, but before the inquest, you spoke to them and you explained what approach you were following and why.
Yes.
Yes. And then what did they say to you?
No, they said they accept my decision, and then they will consider the matter after the inquest.
Yes, I see. And then,
So I had to instruct them to withdraw all the charges, because proceeding with the other charges in the circumstances that an inquest was going to be held, it will just create fragmentation of trials in case the inquest would elucidate further evidence or facts that would convince me that indeed Ndole needs to face a charge of murder.
look, I mean, the strange thing is that we went through this last week. The SCA says that's fine because it's not a problem to avoid fragmentation of trials.
Indeed.
And this is what they're charging you with now here, that, you should have proceeded with the other charges.
No, I take it and accept that that comes because of the misreading or not understanding the SCA judgment.
Yes, I understand. All right. So we are now at the stage where you've spoken to firstly, you've analyzed the docket, you've looked at the memorandum. You've identified weaknesses in the memorandum and in the evidence, and there are gaps, and you say, okay, to satisfy myself, let me rather follow a cautious route of an inquest.
Yes.
If the inquest finds that a case of murder is sufficiently established, what were you going to do?
I was going just to proceed to say, proceed and charge him with all this, the murder charge, the murder charge and the attempted murder charges.
You see, what I need to put to you is, there was another theory that the NPA appears to have been working on, and that is the theory contained in the opinion by Mr. Harley. Let me just take you through that. And they seem to have thought that you had some kind of a double agenda, so if you go back to that opinion of Mr. Harley,
If you can help me with the page.
L04. So I want to look specifically at LO 001056.
056.
Yes.
So 05.
Sorry, 001056.
That will be 1056.
Yes.
Yes, I'm there, Chair.
Now, this seems to me to be the whole problem with this, is that ordinarily you have a prosecutor who's the DPP. He looks at the work of other prosecutors who report to him, and then he says, look, your work has got discrepancies. I need it to be checked by a magistrate. And everyone is happy with that.
Yes,
And that's in the normal course of doing your work.
indeed.
Until somebody then introduces this theory, and I'm going to show you what actually seems to have been the problem. In paragraph 13, this is what Mr. Harley writes. Lieutenant General Mdluli was obviously anxious not to be prosecuted on either set of charges. To avoid prosecution, he had to make representations to two different persons, the special director of the Special Commercial Crimes Unit. Now, you were not involved in that one. That was Mr. Matenjo.
No, it was Mr. Mkhwebe.
Sorry, Mr. Lawrence Mkhwebe.
Yes.
Now, and then he says, in respect of the fraud charges and the director of public prosecutions in relation to the Ramukhebe matter, correct?
Yes.
And then he says, by March 2012, he had succeeded in doing so. The question is how? It is in this context that Advocate Chauke's decisions should be considered. Paragraph 14, the chronology of the events and the context in which Advocate Chauke made the decision to withdraw the charges demonstrates that in all probability he did not act without fear, favor, or prejudice in making the impugned decision. We summarize this case below. I mean, how do you respond to that?
That's a lot of nonsense.
No, well, let's not be rude. But how do you respond to that, that he is accusing you of not acting acting with fear, favor, or prejudice?
No, it's very unfair to me.
Yes, but it's false.
It's false.
Yes. Now, paragraph 15, on 7 July 2009, Lieutenant General Mdluli was appointed as the Divisional Commissioner of Crime Intelligence. His appointment was not made directly by the former President, Mr. Zuma, but it was made under highly suspicious circumstances which need not be explored here. Now, I personally, as an advocate, cannot understand how you can make a statement like this without any underlying facts, because the opinion doesn't contain any facts that Mr. Mdluli's appointment was questionable.
But from what I understand is the theory that was developed because Mdluli said he was being prosecuted because they didn't want him to be appointed as the head of crime intelligence.
I understand that Mr. Mdluli can say anything. He's a witness. It's like Major General Boyson. I don't care.
Yeah.
What I care about is an opinion that is relied upon by the NDPP to prosecute you. And that's why I want your comment on paragraph 15.
It's just unfortunate that the opinion was came with this theory, which is untenable. And
But I mean, are there any facts here that support what is being stated?
no,
Yes. Now, then paragraph 16, Lieutenant General Mdluli and Advocate Nomgcobo Jiba, the former acting NDPP, enjoyed a special relationship with and the protection of President Zuma, and both appeared to have a direct line of communication to the president. Now, again, are there any facts here that now Ms. Jiba and Mr. Mdluli have a close relationship to the president?
not that I'm aware of. Advocate Hali would have.
No, in their opinion.
No.
Yes. But what is the basis then for this?
There's no basis at all.
Yes. Now, then, Advocate Jiba repeatedly told officials within the NPA and spoke openly within the NPA corridors that she had the ear of the president. Lieutenant General Mdluli lodged complaints with former president, and it seems that his complaints were taken seriously. We explored that below. Again, is there any basis, factual basis set out here for this?
No.
Yes. And then, paragraph 17, on 8 September 2010, President Zuma granted Advocate Jiba's husband, Mr. Buka Nancy, a presidential pardon despite warnings from the Minister of Justice, Mr. Jeff Radebe, that Mr. Nancy had not met the most basic requirements for such pardon. This evidence is documented in an affidavit of Advocate Karen van Rensburg that was filed with the State Capture Commission and appears on its website. This case is amply supported by the documentation attached to her affidavit.
No, there you have it.
What do I have?
That the theory came from Karen van Rensburg.
Yes.
Yes.
Advocate Karen van Rensburg.
Sorry, Advocate Karen van Rensburg.
Yes. But it's not tested anyway. There's no trial. There's no cross-examination. Nothing. It's just people's own thumb sucking.
Yes.
Yes. Then, a day later, a person bearing the name of Nomgcobo Jiba, and this is really, you have got to look at this. It's truly astonishing what is said here. A day later, on 9 September 2010, a person bearing the name of Nomgcobo Jiba, who apparently had a different identification number, and Lieutenant General Mdluli traveled together on a flight to Durban. Advocate Jiba was confronted with this evidence in the Mokgoro Commission of Inquiry. She denied that the person in question was her. Given the surrounding circumstances, it seems, with respect, far too coincidental that it was not her. Now, what do you make of this?
It's very unfortunate.
But in terms of the evidential quality that you would expect from a senior counsel advising the NPA, that you just rely on your own speculation.
That's why I'm saying that he looked at the gossip and the innuendos from people in the NPA, like Advocate Karen van Rensburg. You would remember Advocate Karen van Rensburg is the one who filed the affidavit in the where the NPA was alleging that it was not represented in this inquiry, when the contrary is correct. So I'm not surprised at all.
Yes. Then, on 11 November 2010, Lieutenant General Mdluli addressed
Sorry,
it.
before you continue, all these allegations that are being mentioned, especially at paragraph 17 and 18, went to the State Capture Commission.
Yes.
Do we know whether there was any pronouncement on any of this, or what was the outcome? I'm looking at paragraph 17, where it is said that Mr. Nancy, whom we know that it's Advocate Jiba's husband, was granted pardon despite warnings and that he had not met the most basic requirements for such pardon. Did the State Capture Commission make a pronouncement on this, or was there an effort to review this decision? Because if it was taken arbitrarily, it is an administrative decision that can be reviewed. Was there any pronouncement, or was it reviewed? And maybe let me just lump it with what is contained in paragraph 18, where Advocate Jiba says, the person that you're talking about is not me. Was there anything further done to try and prove that it was Advocate Jiba for us to be dealing with it now, entertaining it now here?
Chair, not that I'm aware of. As indicated when Advocate Shamila Batoy testified here, she said regrettably the Zondo Commission did not make any findings. Now, what has happened here, because I also filed an affidavit at the Zondo Commission, when it was supposed to be our turn to respond to the allegations from Karen van Rensburg et al. The Zondo Commission said this was not within their terms of reference, and then they will refer them back to the NPA to be dealt with. That's why when she was Advocate Shamila Boto, when she was here, she said, regrettably, Zondo Commission did not make any findings.
So the NPA did not do anything after being told by the State Capture Commission that this is outside their terms of reference?
Not that I'm aware of. What had happened thereafter is this process that we are in now.
So we can simply disregard this because it does not take us anywhere. I mean, we do not have to advocate. Jiba is not before us. It's only her decision in relation to the Katomena that is before us. But other than that, the rest of this are not relevant to our terms of reference, unless if they show something that I'm unable to grasp.
Chair, they just saw the appetite that Advocate Karen van Rensburg, Advocate Batohi, some civil society groupings they had at Jiba. This is what I can sum it that way. This appetite about her and what have you, I don't know.
Thank you.
May Council, the issues referred to at RM 00883, that the cryptic issues, you remember the 6th paragraph that Advocate Kwetobi referred you to earlier?
883?
883, RM 00883 is volume 4 of Mdluli. It's a prosecution memorandum. In which the representations by Advocate Mdluli, yes,
I'm there.
Advocate Pardon, General Mdluli, yes. The first issue regarding the murder charge and the attempted murder charge, they say, was based on circumstantial evidence.
Yes.
It is for that reason that you referred the matter for inquest.
Yes.
Can you just elaborate for those who do not understand what circumstantial evidence is?
Yes, Chair. Circumstantial evidence shows that you don't have direct evidence to link the accused with a particular offense. You rely on circumstances and inferential reasoning to conclude that this might be the person who is responsible. Now, in that kind of reasoning, when you reason, you must exclude other possibilities in respect of that circumstantial or inferential reasoning. At the end of the day, circumstantial evidence, at times you will have some facts outside of that which might corroborate that circumstantial evidence. And in this instance, my reasoning was that there are no other facts other than that there is this love triangle, which is supposedly the main cause for his death. And once one reason with those kind of circumstantial evidence, you must draw the conclusion that one inference which points to that. And in my thought and in my reasoning, that was not the only conclusion that one could reach based on the facts as I had them at the time.
Will I be correct, given in your experience as a prosecutor, a very experienced prosecutor, that when you are faced with circumstantial evidence and you have to make a decision whether to prosecute or not, or to go to trial, proceed to trial or not, you often encounter challenges in formulating a conclusive view that there is indeed a prima facie case.
Indeed, Chair.
Am I correct?
You are correct, Chair.
Now, with this background, looking at the opinion of Advocate Halley, where they tabulate all these things that they are mentioning, which seems to me to constitute gossip.
Indeed, at the highest level.
Is there any way in this opinion, I might have misread the opinion, wherein the writers of this opinion deal with those aspects of the circumstantial evidence?
Not that I'm aware. Not that I'm aware, Chair. I tried to also go through it from time to time when I knew that I was going to come here, and I couldn't really see where they actually discussed the actual effects and the actual evidence.
In the absence of any analysis of the circumstantial evidence that you were confronted with, that might have assisted in coming to a reasonable conclusion whether you were wrong or not. What do we then make of this opinion? From those paragraphs where reference is made to you having acted, that you did not act without fear, favor, or prejudice, that you relied on those things that have been mentioned in those paragraphs, without the analysis that I'm mentioning, what should we then make of this paragraph?
I respectfully submit that they must be ignored and not be taken into account, because it's untenable and not based on evidence, what is contained on those paragraphs.
Now, the suggestion at paragraph 14 of the opinion that in all probability you did not act without fear, favor, or prejudice, you know that is a serious allegation.
I know, Chair. And
it is serious because of your constitutional and legal obligation as a prosecutor. Correct?
Correct, Chair.
Now, the averments that you did not act without fear, is it based on those paragraphs? For instance, paragraph 15 and 16 regarding the mentioning of the appointment of Mr. Mdluli by President Zuma, and that General Mdluli had a special relationship with Advocate Jiba, that Advocate Jiba's partner was given presidential pardon. I'm just mentioning in summary those aspects. And I'm just trying to determine what relevance are these aspects to the allegation that you were fearful.
To the contrary, I was not fearful for that simple reason that if I was acting with prejudice and the like, and I was to confirm to this theory, then it means I would simply have withdrawn the charges against Mndluli in their entirety. But because I was acting without fear or favor or prejudice, I had to look at the facts and satisfy myself that there is justification for the charges, one way or another. In summary, Chair, I acted without fear or favor or prejudice.
Hence,
Because
you
this
get-
reasoning, which is here in this paragraph, is prejudicial in themselves.
and it's not consistent with your decision referring the matter for inquest.
Indeed, Chair.
Yes, thank you.
Thank you. Mr. Chauke, let us not poison this forum further by emphasis on the gossip.
Thank you, Chair.
I just want to answer something directly on this line that the chair was engaging you with, which is, if it was true what Advocate Harley has written there, all of that gossip, what did you actually do? Now you've got the results of the inquest. They say that on murder, it's no good. But what did you do, as a matter of fact?
I did nothing wrong, Chair. Because immediately after the findings of the inquest, I called in the prosecution team to say, here we are. You guys must now amend your indictment and proceed with all these other charges.
Yes.
Then the team leader, Advocate Van said, he says, no, I heard that your decision to refer the matter to for the inquest is being reviewed by the High Court in Pretoria. And in that sense, we cannot proceed with the matter on trial given under the circumstances, which I agreed with him because it made sense that one will have to wait for the judgment from the High Court, which was delivered by Murphy J. Yes. And then after the judgment was delivered against the NPA, NDPP, that decision was appealed to the SCA. And the SCA came out with the judgment that determined that my reasoning and the process that I followed was rational.
Yes. But also they affirmed you on the fragmentation issue.
Yes.
Insofar as they're talking here about the delay in the other charges.
Yes.
But the point I'm saying is, what did you actually do against Lieutenant General Mdluli? You remember that this is the person via gossip that they are associating you with. And Advocate Jiba and President Zuma, the whole conspiracy that they have cooked up at this Advocate Van Rensburg's affidavit. But you have a choice to say, am I charging this person? Because if you're part of this, large conspiracy, what did you actually do?
No, I charged Mdluli in respect of all the other offenses of kidnapping, assault, and on the victims. If I really had anything to do with him that I was protecting him, I probably would have found a reason not to proceed with those charges, given that there were even more than 10, 11 years, which is irrelevant. The fact of the matter is I was faced with a decision to make there, and I made it accordingly without any fear of ever prejudice.
But as I understand, you are in fact the only person who's ever charged Lieutenant General Mdluli.
Yes.
And then what happened after that? Once you charged him, you went to a trial?
We went to a trial and they were convicted and they were sentenced to 5 years imprisonment.
Yes.
Yes.
Which has never happened before.
Yes.
And then the only person who ever charged Lieutenant General Mdluli is now being accused here, strangely, of trying to protect him. But you send the man to jail for 5 years.
Yes.
Yes.
During the testimony of Advocate Batoi on this aspect, when we asked her as to what the problem is in relation to you having withdrawn the murder charges, my recollection, subject to correction, was that she said you did not reinstate the charges.
Yes.
If my understanding is correct, he meant, unfortunately, she left before we could canvass those issues with her. My understanding of her testimony was that your failure to reinstate those charges after the decision of the Supreme Court of Appeal is what really gave the problem and led to her doing what she did. Because she seemed to have understood that withdrawal per se does not put an end to a case, a criminal case. It can, at a later stage, be reinstituted. Is my recollection of events correct?
They are correct, Chair. What has happened, as I indicated, there is the misreading or misunderstanding of the judgment. Once the SCA made the judgment, it took the decision to decide on the matter and the matter and charge back to the took it to the national director. I couldn't, in terms of that judgment, make a decision myself, because that decision became now the decision of the NDPP to make, which he made. So how Advocate Batoi and those around there could consider even the opinion controlled that I failed to reinstate the charges once they were withdrawn, it's beyond comprehension.
If we can just, maybe if you remember where we find Brand J's order. Brand JA's order, brother.
I'm sure it is CL. CL 00371. That's CL2.
00371.
71.
Thank you, Council.
I'm there, Chair. I got it.
Paragraph 54, the order of the Supreme Court of Appeal. Would you just quickly read the order?
Thank you, Chair. In the premises, it is ordered that 1. The appeal succeeds only to the extent that paragraphs B, E, and F of the order of the court are set aside. 2. The orders in paragraphs A, C, D, G, and H of the order by the court are confirmed, but renumbered in accordance with the changes necessitated by the setting aside of the orders in paragraph 1. 3. It is recorded that the following undertaking has been furnished on behalf of the first appellant. A, to decide which of the criminal charges of murder and related charges that were withdrawn on 2nd February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some or if any of those charges. 4, there shall be no order as to costs in respect of the appeal.
As regards Order 3A, as you mentioned, the matter was now in the hands of the NDPP.
Yes,
This time it was Advocate Nkasana, correct?
it was Mr. Ngasana.
The matter was now out of your hands.
Yes.
Thank you, Council.
Thank you, Madam Chair. Can you go to your bundle where there's your statement together with its attachment and go to page 6A 161?
Maybe before we go through that bundle, I should ask questions. I thought you're still going to be working on this portion, but then, yeah. Advocate Chauke, you say that your decision was different from that, or your view was actually different from that of the prosecution team that was looking at the Mdluli matter, the matter in particular.
Yes.
Correct. And you engaged the prosecution team about what is concerning to you, and nevertheless, as a cautionary measure, you took this matter, you referred it for inquest.
Yes.
And you say that the members of the prosecution team, the very prosecution team that had decided that the matter should be proceeded with on prosecution, are the ones that led evidence, witnesses' evidence at inquest.
Yes.
At the inquest, yes.
Yes.
And once the inquest was concluded, the magistrate gave its ruling, its decision.
Yes.
Now, do you know as to, upon receipt of the decision of the magistrate, what was the view of the members of the prosecution team, the very ones that were actually active at the inquest? Were they satisfied, according to your observation or even what they said, about the decision of the magistrate, or was there any issues from them?
According to me, they were satisfied. They understood the reasoning of the magistrate, and I did not take it any further from there.
Okay, yes. So they too now were satisfied with your thinking and agreed, based on the reasoning of the magistrate, that you were actually correct.
Yes.
Now, after the receipt of the inquest outcome, you then directed the prosecution team, Fanzale and them, to then proceed with the other matters.
Yes.
And how can we describe this? Can we say that you gave a directive that the other matters be proceeded with without delay, or did you delay in some way or the other?
I did not delay it at all. I think it was 2 or 3 days thereafter, once I received the record of the findings from the magistrate, and having studied that, I called the prosecution team, and I explained to say, given what has happened and the reasoning of the magistrate, I'm satisfied that the decision that I've made is correct. You can proceed with the other charges.
So this actually suggests that the question whether to proceed with these other matters depended on what the outcome would be, but in respect of those matters, you were resolute on proceeding with the prosecution. The only thing that you were trying to avoid was staggering the matters. Is that a correct conclusion?
That is correct.
And would you say that the NDPP or the NPA actually ought to have become aware of the fact. Let me rephrase it. I don't think I'm asking that. Right. Now, but for the advice from the prosecution team that the decision of the magistrate was, the judgment of the magistrate was under review, these other matters would then have been proceeded with.
Yes.
Now, reference to, I see Advocate Hali's opinion has spent a lot of time dealing with issues that concern Advocate Jiba. And I look at that memorandum, that opinion. It was written in 2023. Is it correct that that was long after Advocate Jiba had left the NPA?
Yes.
Thank you.
And Mdluli and the others were by then, I think they were in prison, serving the 5 years.
Right.
Yes.
Thank you. That's a bonus answer. No? Thank you.
In relation to which charges?
In relation to kidnapping, assault, and defeating the end of justice charges.
Yes.
And you may?
No, I'm happy to yield.
Yes,
Madam
thank you.
Chair.
And I thought that the point that I asked you about Order 3A of the Supreme Court of Appeal, just to take it to its logical conclusion, the charges were subsequently reinstated.
Yes.
That is the murder charge.
No.
What happened to those charges?
Mr. Ngasana made the decision that there is no enough evidence to proceed on the murder and attempted murder charge, and he informed the freedom under law accordingly through Cliff Decker attorneys.
What decision then did he make? Nolle prosecute?
He made a nolle prosecute in respect of murder and attempted murder charges, and indicated that the trial is going to proceed in respect of the other charges as directed by me.
Yes. Was there any challenge to that decision by anybody?
Not that I'm aware of.
Thank you.
Thank you, Madam Chair. I think we were actually on the same point. I was going to ask the witness to look at 6A/161 of the attachments to your statement.
Yes, I'm there, Chair.
Yes. What is that document?
It's a letter written by Mr. Ngasana, the National Director of Public Prosecution, to Tricia Erasmus, Senior Associate Cliff Decker, Hofmeyer Incorporated, dated the 17th of June, 2014.
And then can you just read the contents of that document?
Dear Tricia, the above matter in your letter, facts dated 5 June 2014 refer. Kindly be advised that after careful consideration of the evidence contained in the dockets as well as the transcription of the inquest record, the state has taken a decision to reinstate the following charges against Mr. Richard Nagi Mdluli. 1. 5 counts of contravention section 1, subsection 1B of the Intimidation Act 72 of 1982. 2. 2 counts of kidnapping. 3. 2 counts of assault with intent to do grievous bodily harm. 4. 2 counts of assault common. 5. 1 count of defeating and or obstructing the end of justice. Due to the high-profile nature of the matter, the state is considering arraigning the accused in the High Court. Please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage, due to the lack of evidence implicating him thereto.
If you can just
Please.
stop there. No, just stop there, because he's then talking about fraud and corruption, which was Mr. Mkwebe's department. Your department was murder and attempted murder.
Yes,
You had come to the exact same conclusion yourself earlier.
indeed.
And now your boss also comes to the same conclusion after reading the dockets.
Yes.
Now, the funny thing here is a withdrawal doesn't mean the end of the prosecution. You can reinstate if you find the evidence at a later stage.
Yes.
After Mr. Ngasana left, there was another NDPP who was Mr. Sean Abrahams.
Yes.
Did he reinstate the charges of murder against Mr. Mdluli?
No.
After Mr. Abrahams, there was another NDPP, Advocate Patoy, who seems to have been concerned about the withdrawal of the case. Did she reinstate the charges?
No, she did not. That's why I make it in my statement there to say, even as I'm sitting here today, she has never taken that decision to charge Mdluli with murder and attempted murder.
Yes, and does murder prescribe?
No.
Yes. So she had 7 years to charge Mr. Mdluli if she believed that there was a good case against him, and she didn't.
Indeed.
Yes. Sorry, you wanted... Sorry.
Follow up on that one. Advocate Batohi, in her evidence and also even in her affidavit, she states that you weakened the murder charge by delaying prosecution. Are you able to help us understand what that means in the context of your work as a prosecutor?
No, to the contrary. One was able to determine whether that theory or the circumstantial evidence will stand scrutiny in court, which it was not. So she's saying directly the opposite, because the opposite will also be true, that at the inquest, it could be that the evidence there will come and show that indeed this circumstantial evidence is strong, and then it's the only inference that can be drawn that Mdluli who killed Ramokhibe at the exclusion of any other person.
Can you enlighten us about what could weakening a case mean, especially in the context of your exercise of your obligations as a prosecutor? Instances where we can really point out that indeed these are factors which can contribute to the weakening of the case at the hand of the prosecutor.
You'll find the rare instances of that happening, because in a case where a witness is subjected to double cross-examination, that is cross-examined at the inquest and then being cross-examined in the actual trial, there's a potential that you think that the witness may contradict themselves in the subsequent trial and the like. That's the only reasoning that I think maybe she was thinking about it.
Yeah,
Anything more than that, it will be a figment of an imagination that will happen.
Okay, thank you, sir. Thank you.
Thank you.
Okay, Toby, I'm reminded that it is tea time.
Yes.
But before we pause, let me just clarify with the witness. Following the letter by Advocate Nkasana, or decision, let me not refer to it as a decision, 6A-161, where he said, please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage due to the lack of evidence implicating him. You said that this is a nolle prosequi decision. You understand it to be that?
Yeah, I understand it to be there at that stage.
Now, what avenues were or options were open to Advocate Batoyi if she was of the view that the murder and attempted murder charges against Mr. Mdluli should have been proceeded with?
If she had evidence which would have come to light between then when Mr. Ngasana made this decision and her coming into office, she will be entitled to reinstate the charges, to make a decision to say the murder and the attempted murder charges should proceed.
That's where my problem is. I don't understand this sentence to mean withdrawal.
Yes.
I understand this sentence, and correct me if I'm wrong. The decision Advocate Gasana is taking here is not a withdrawal.
No.
It's a nolle prosecute decision.
Yes.
Now I'm asking you, in the face of that kind of a decision, in your understanding of criminal proceedings, what option was then open to Advocate Batoyi if he was of the view that the prosecution should have been proceeded with?
It was to go back to the court and ask for the court to review the decision and consider factors that she would have had in a position to indicate that that decision was unlawful or was irregular. In the same vein that Freedom under law went to court to challenge the decision not to prosecute, she could have done exactly the same way to indicate that she wants that decision reviewed, and then that the court will consider and make a decision.
But the freedom under law one was different because yours was a withdrawal,
Yes.
not a decision not to prosecute.
Yes.
Is my understanding correct?
Correct, Chair.
Here, it is a final decision, if I may call it that, not to proceed with the prosecution.
Yes.
And in that instance, anyone who was of the view that the prosecution should have been proceeded with would have taken certain steps. And you say Advocate Batoyi should have gone to court to review this decision of Advocate Nkasa.
Yes. Or freedom under law then, when the decision was made and they were not satisfied, they would have approached the court for them to challenge that decision of Mr. Nkasa.
Yes, freedom under law is not before us. There's no complaint by them. The complaint is by Advocate Batoyi.
Indeed,
That-
Chair.
yes. We have now crossed that first hurdle regarding the withdrawal by you. The SCA has pronounced on that. The matter has now gone to Advocate Ngasana, the NDPP, in whose hands the matter was, and he decided, I am not proceeding.
Yes.
That should then have brought the matter to an end.
Which is what had happened. The matter was concluded then.
Thank you.
Thank you, Madam Chair. Sorry.
Yes, the matter was then brought to a halt by the nolle prosequi, as my sister has stated, that, I mean, there is a clear difference between a withdrawal and you cannot exercise certain powers in respect of a withdrawal. Is it also not so that maybe the only option open for a person, not just focusing on Advocate Batoyi, because then we'll talk about her office later if necessary. Once a certificate of nolle prosequi has been issued, is it correct that those who have an interest in the matter would then have a right to institute private prosecution proceedings?
Yes.
But looking at the office held by Advocate Batoyi, would even that be open to her? Because people go for private prosecution because they think or they believe that the prosecutor has failed to exercise its decision properly. And the decision that comes from the NPA becomes the decision of the NPA.
Yes, she's functus officio.
She's functus officio, and she would not, that would also not be open to her.
Yes.
Thank you.
Yes.
Just the last question. On that aspect of the terms of reference, term 3.1.2,
I'm the chair.
if I may quickly just read it, the failure to continue with charges against Lieutenant General Richard Ndluli for his involvement in the murder of Mr. Tefo Abel Ramogibe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramogibe and related charges to be withdrawn.
Yes.
We have crossed that hurdle.
Yes.
Notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, we also dealt with what seemed to have been relied upon by Advocate Halley and others in the opinion that gave rise to this issue. Is there any other evidence, in your view, apparent from the affidavit of Advocate Batoyi, other than what we have read in the opinion of Advocate Halley, suggestive of a strong evidence?
No, Chair. Even from the prosecution team themselves, they've never used this word strong evidence. They said there was circumstantial evidence.
Well, we will probably have the benefit of hearing from Advocate Batoyi if she decides to come back and take that stand, or from any other witness who may assist us in establishing whether indeed there was such strong evidence referred to.
Indeed, Chair. It would be nice to hear the legal mind of Advocate Shamila Bato in that respect.
Yes, thank you. I don't know whether you want to close this chapter or you want to deal with other aspects. If you want to close it with few questions, maybe we should do that so that you can lap into the last few aspects of your case, if necessary.
Yes, Madam Chair. No, it's just to go back to the prosecution memorandum, which is the source of this. It's actually at RM 00883. The witness points to the fact that the charge talks about strong evidence and it is disconnected from the prosecution memorandum, which is the basis on which they are relying. Now, if you look at item 1 under issue 2, strength of the state's case, it says the case on the murder charge relies solely on circumstantial evidence. Those include a threat by the accused to the deceased family that the deceased will be killed. Now, then, if you look at item 4, which is actually, I think that actually the attempted murder charge is irrelevant because it's not in the charge. The only issue to be concerned with is the murder charge.
I take it when they say and related charges, when you read the terms of reference, that's how.
No, but where do they say related charges?
Where they say a charge of murder relating to the killing of Mr. Tefo Abraham Khibe and related charges to be withdrawn.
So you would read related charge to be murder and attempted murder?
Yeah.
Okay, well, we can take that generous view. But then in paragraph 4, we are still back to where we started, paragraph 4 of the prosecution memo. It
Yes.
says the attempted murder charges, count 13 and 14, are also based on circumstantial evidence.
Yes.
So this is where the disconnect is. And then you look at the charges. The judge then invents a phrase, strong evidence.
Yes.
But that was not the opinion of the prosecution team.
Yes.
Yes. Madam Chair, I'm just going to do literally the last 3.2, which are the conclusions, and then I would like to stop so that we can have enough time for the cross-examiners. So if I could just do that quickly in 5 minutes before we adjourn.
Council, I think you should then finish.
Yes,
on
thanks.
this aspect.
Thank you, Madam Chair. If I can take you back to your terms of reference.
I'm there, Chair.
So in paragraph 3.2, they say, whether in fulfilling his responsibilities as Director of Public Prosecutions, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold this position and be a member of the prosecutorial service. What is your answer to that? Did you comply with the Constitution? Did you comply with the NPA Act? Are you fit and proper?
Fully. I complied fully, and I'm fully fit and proper.
Yes. 3.2.2, whether Advocate Chauke properly exercised his discretion in relation to instituting and conducting criminal proceedings on behalf of the state, carrying out any necessary functions incidental to the institution and conducting such criminal proceedings, and discontinuing criminal proceedings. Did you properly exercise your discretion in relation to those 3 aspects?
Yes, Chair, I did.
Yes. Then whether you duly respected court processes and proceedings before the courts as required by the applicable prescripts, and as a senior member of the National Prosecuting Authority, did you respect courts?
I respect courts directly opposite those who came before the inquiry, because they don't respect the courts.
Yeah, well, they're asking you to revisit court findings, so that says a lot.
Yes.
And then whether you exercise your powers or performed your duties and functions in accordance with the prosecution policy and policy directives as determined under Section 21 of the National Prosecution Authority. Did you respect prosecution policy and prosecution policy directives?
Yes, I did, Chair.
Whether you acted at all times without fear, favor, or prejudice. Did you act without fear, favor, or prejudice?
Indeed, Chair.
Yes. Whether he displayed the required competence and capacity required to fulfill his duties by, among others, objectively engaging the facts presented to him impartially, in good faith, and without fear, favor, or prejudice, subject to the Constitution of the Republic of South Africa and the law, in order to discharge his duties as a Director of Public Prosecutions. Did you fulfill your functions in accordance with the required level of competence and capacity?
That's my view, that I fully complied with that.
Yes. And then whether he acted in a manner which brought the National Prosecution Authority into disrepute by any of his actions or omissions. Did you bring the NPA into disrepute?
Not at all.
Yes. Now, will you, I understand that you've obviously not been happy that you've been suspended and you've been subjected to an inquiry and you feel there's a lot of unfairness.
Yes.
But the fact of the matter is that if you are not found guilty, you have to go back to the NPA.
Yes.
And you have to work with some people that you would feel have been unfair to you. Advocate Karen van Rensburg is one of them that you've specifically mentioned. I don't know if there are others, but Advocate Batoy is gone, so there is no issue there. But you have to work with people that you feel have caused you wrong. What is your view on that?
No, it happens in life and in work environment that you differ as colleagues, and then work must continue. There's really no issue.
Yes.
Yes.
But you will be happy to go back and to continue with your work without any feeling of animosity.
Indeed.
And the president should not be concerned that this act of suspending you and taking you to a disciplinary hearing has somehow impacted your ability to fulfill the functions as the Director of Public Prosecution.
Not at all, except that in terms of the life outside there, and family and whatever, that this obviously they also would like it to be concluded. And if it's concluded that indeed I'm innocent and the like, the president had to follow this due process for him to be able to make a determination, and I've got no qualms with that.
Thank you, Madam Chair. I have no further questions for the witness.
What are you saying about family?
Once you're being accused for almost 7 years, you're in the media, you are corrupt, you are captured, there are these decisions, so that it affects everybody around me to say, really, are you that corrupt? What's happening? And they're like, and you have to explain yourself over and over again. And that at times you sit with them and then you look through their eyes, you can see that they are so much worried about this conduct and the like. But now that this inquiry, since the start of this inquiry, and they hear that there is nothing about me being corrupt and all sort of things, there's just is that burden and all sort of things. And to me as a person as well.
You must be happy that the president agreed to institute this, to establish this inquiry.
Indeed. Everybody around me, they said that this is the best that could have happened, because if this did not happen, I just maybe decided to resign, to leave, and what have you. The truth that South Africa knows now, they would not be in a position to know.
Well, this panel has not made any decision thus far,
Yes.
but at least South Africa has been listening.
Yes.
And your family has been following these proceedings,
Yes.
listening to witnesses,
Yes.
and making their own view. But this panel has not made any decision whatsoever.
Yes, I'm now referring to my family, and I like to say to them, this has been a good opportunity, and that has presented them with the opportunity to really see what is happening and understand from that background.
Because they've listened to the witnesses who testify.
Yes.
Thank you.
Thank you, Madam Chair. I've got no further questions to the witness.
You are closing your case?
Well,
I mean,
after he's
insofar
crossed,
as this witness is
so far as
concerned.
this witness is concerned, yes. I'm going to close my case very soon, Madam Chair. I know that I should.
Yes, that ends the evidence in chief of Advocate Chauke. We will take a tea break. Now that I have difficulties in working upstairs, I will take 30 minutes.
Thank you, Madam Chair.
Yes, thank you. We will reconvene at 10 past
Thank you.
12. Good day, everyone. Good day, Advocate Shauke.
Good day, Chair.
You continue to be under oath.
Thank you. I confirm, Chair.
Advocate.
Thank you, Madam Chair. Good day, Tatana Chauke.
Good day, sir.
How are you?
Fine, thanks, and you?
I'm okay. You read documents. As you indicate in your document that you presented before this tribunal, you read quite a number of documents. We don't have to go back to them.
Yes.
Now, in your role as a coordinator, did you have to read so many documents and dockets as well?
Yes.
The reason being?
When I had to assist Advocate Jiba in the review application, which was brought by Boys.
To assist him by giving him a briefing. Maybe if you may explain that.
When there was a review application brought by Johan Boysen, Advocate Jiba had to file an opposing affidavit in respect of that matter.
Okay, apart from that, Advocate Chauke, you indicated in the document that you presented before this tribunal, documents that you read.
Yes.
Were all the documents that you read that you are indicating that document for the purposes of briefing Advocate Jiba?
Settling the affidavit with counsel who was preparing the opposition to the application by General Johan Boysen.
Okay, let's go to page 3 of the document.
Yes, I'm there, Chair.
You are there. These are the documents that you read. Monetary awards for Boysen and Katomana unit. And date of document was the 14 October 2008. Was that for purposes of the review application?
Yes.
Okay. The High Court application by Bongani Mkhize, was it also for the High Court application?
Yes.
As well as the last one on that page, the meeting of 9 March 2012 with DPCI at the NPS head office.
That is a meeting, sir.
Yeah, but you indicating that there's an email down that you indicate there. There's a bullet.
Yes.
Now let's go to the next page. I'm not going to refer to each and every document. You have done so in your evidence in chief. All these documents that appear on this page, page 4, were for that purpose as well.
Yes.
To brief Advocate Jiba in the review application of General Boysen.
Yes.
Okay. You also read the DeCock report on page 5, not so?
Yes.
That's also for that purpose.
No, sir.
Okay. Let's proceed. Now, in your evidence in chief, Advocate Chauke, you told this tribunal that Advocate Batohi purged black prosecutors. You remember?
Yes.
Did he only charge black prosecutors with misconduct?
in relation to Katomani.
Yes, in relation to Katomana.
Yes.
Was there no colored in the mix?
Colored, as I understand it, is black.
Was there no Afrikaner
Not that I'm
in the
aware.
mix?
Not that I'm aware of.
Okay. Did Advocate Patohi ever show any, before that, if she, according to your evidence, she purged,
Colored, you mean people of mixed race?
that's what I mean, Madam Chair.
Thank you.
If you say she purged black prosecutors, are you suggesting, correct me if I'm wrong, that Advocate Patohi is racist?
No, I'm not suggesting that, but that she's racist or not, you may check with her, because when she was interviewed for that job, she was asked about this racism, and she had an answer then.
She had an answer.
Yes.
That she was not a racist.
I
Or
don't
what,
know.
what was her answer?
I don't know to what extent was the answer, but I remember her saying that she was surprised that there were those allegations against her.
Were you part of the panel that interviewed her?
No, I was also interviewed. I
For the-
watched the interview.
I see.
Yes.
Did she ever show any, when you were colleagues, did she ever show any tendencies of being racist towards you?
Towards me?
Yes, you in particular.
No.
No, thank you. I'll proceed to other issues. From your short resume, Advocate Chauke, one can decipher that you possess a wealth of skill and experience as a prosecutor, not so?
What is the meaning of deceiver?
I could make out
Oh, okay.
from your short resume.
Okay.
Do you agree with me?
Yes.
You possess a wealth of skill and experience, which is commendable.
Thank you.
Now, let us take this general scenario. As a prosecutor, in particular as a DPP, after you shall investigate the case, it's a general scenario. You should teach me if I don't get it right. You then prepare an indictment, which is accompanied by a prosecution memorandum. Is that correct? Am I?
No.
How do you go about it?
About what?
Are you
A
asking
proce-
just a general question about his prosecutorial functions generally, or in relation to a specific matter pertaining to this inquiry?
I'm asking about a general scenario where an accused person has to be arraigned in the High Court. After investigation shall have been done, before you prepare an indictment, up to the stage of indictment, you then prepare an indictment and then a prosecution memorandum. How do you go about it?
No, if a prosecutor arranges to prepare an indictment to arraign a person in the High Court or in the regional court, there's no prosecution memorandum.
At what stage do you prepare a prosecution memorandum in a normal course of events?
When you want somebody other than you, a DPP or NDPP, to make a decision.
I see. Let me direct your attention, Advocate Chauke, to paragraph 117 of your statement. Which you'll find on page 6-32
1-1.
7. It's on page 6-32.
Yes, I'm there.
For the sake of the record, I will read it yet again because it was already read. You say there, on or about 11 June 2012, I met with Mr. Bierkman of IPIT and Advocate Matenjwa to review the status of the investigation. And on or about 12 June 2012, I convened a meeting with General Mabula and the prosecution team to discuss updates. On the same day, I received the draft indictment and supporting summaries prepared by the prosecution team, unquote. You see that?
Yes.
Now, from whom did you receive the draft indictment?
From the prosecution team.
In particular, from whom in the prosecution team?
I don't remember, but the head of the prosecution team was Advocate Mayema.
In the same sentence, in the same paragraph, you refer to supporting summaries. I'm lost here as to what supporting summaries mean. If you can explain to this panel, what are supporting summaries?
The prosecution memorandum.
Which you also received from the team, the prosecution team.
Yes.
The sentence as it reads and as it is understood mean that you received the prosecution memorandum and the draft indictment on the 12th of June 2012. Not so.
Yes.
Go to the next paragraph of your statement, that is paragraph 118 at page 6-33. I propose to read it into the record. It says, on this day, my personal assistant, Mamiki Suping, emailed the draft cover letter to acting KZN DPP Advocate Mlochwa. He had been acting in this position since December 2010, unquote.
Sorry, Councillor, which paragraph is that?
118, Madam Chair.
118.
Yeah, on the next page, 6-33, just at the top.
Oh, thank you.
If you say on this day, we should understand it to mean the 12th of June, 2012. Not so.
Yes.
You state in this paragraph, Advocate Chauke, that you sent a draft cover letter. You emailed, your PA emailed, personal assistant emailed the draft cover letter. I'm confused. Can you direct this panel to what you refer to as a cover letter?
I refer to the indictment that she sent together with that covering letter that she emailed to him.
By a covering letter, you referred to the email that your PA, Mrs. Suping, sent to Advocate Mlochwa.
Yes.
You call that a covering letter.
Yes.
Let's go to it. let's go to the covering letter and see what covering letter you are referring us to. Assist.
From where I'm sitting, I
Beg
don't
yours?
remember. From where I'm sitting, I don't remember. Can't locate it. Just,
You can remember.
Yeah.
Okay, fine. We will locate it. In fact, you mentioned it elsewhere in your affidavit. You referred to the mail exchange between yourself and Advocate Molochwa, which appears in paragraph 144 of your statement.
yes.
If you can go to
even the
6
following
point-
paragraph. Even the following paragraph. You read 118. You read 119. That's the follow up to that.
Yeah, we're trying to locate the email exchange, where the email of your assistant appears. You mentioned the page there in paragraph 144 as B00574. Now, if we go to B00574, which is in bundle B2, Madam Chair. It starts in bundle B2, but specifically it goes to B3. 577, it's found in B3.
I'm there.
Now, go to the previous page. That's where Mamiki Suping's email to Advocate Molochwa is located. Do you see that?
Yes.
And it says subject indictment, Katomana.
Yes.
There was no message from Mamiki Suping. Not so. There's no
Yes.
message here.
Yes.
Which one is a covering letter that you say was sent? Because there's no message here, according
you are
to
reading there.
how we read this.
What you are reading, that email, is a covering letter that I'm referring to.
It's a covering letter.
Yes.
Now, if you go to paragraph 119, remain on the same page. Remain on the same page, Advocate Chauke. If you go to 119, you're saying there a disagreement subsequently arose regarding the sufficiency of the documentation, with Advocate Molochwa refusing to sign the cover letter in the absence of the prosecution memorandum or the original case dockets.
Yes.
Was Advocate Molochwa refusing to sign a cover letter, or was he refusing to sign an indictment?
The indictment.
You made a mistake by saying cover letter
Yes.
because it's incorrect.
Yes.
I don't want to say you are lying. No, I will not say so. It's a mistake.
No, it's okay. I can accept if you say I'm lying.
I'm not going to say that because I respect your office. And now, let us try the best of our ability to find whether the indictment that you sent, that you say you found from the prosecution team, was actually received from the prosecution team. And in this regard, my colleague will assist me here to find evidence of Advocate Maema when he was under cross-examination and see what he said. If Madam Chair can bear with me, let me be assisted by Advocate Mtsweni.
Yes, what are you locating? Maybe we can help.
It's a transcript of day 30. Transcript of day 30, where Maema was under cross-examination. Dated 20 February, Madam Chair, February 2026. Where Advocate Maema was being asked about this indictment. Which one is it? On page 45 of 194, if you can go there.
Page 35.
45, Madam Chair,
Oh,
of 194 of the transcript of day 30.
yes, thank you.
Advocate Mtsweni was asking questions and he started as follows. Yes, and you then said, from the week of the 27th May, you were attending in Durban on a weekly basis. Advocate Maema said, that is correct. Advocate Mtsweni, and at that time, you were still busy sifting through all these dockets. Advocate Maema, yes, we were analyzing the docket, guiding the investigations. Advocate Mtsweni, yes. Advocate Maema, yes. Advocate Mtsweni, you had not taken the decision to arraign anyone. Advocate Maema, that is correct, yes. Advocate Mtsweni, and you had not drafted any indictment. Advocate Maema said, that is correct. Advocate Mtsweni, right? So therefore, if anyone says, and you said the decision to arraign, when you then decided to arraign was taken, you then said you took the decision to arraign people on the 29th of June. Do you recall that? Advocate Maema said, that is, I recall that. Advocate Mtsweni, yes, and that is when you then embarked on the process of drafting the indictment. That is correct, yes. That's Advocate Mtsweni, and his Advocate Mtsweni says, and therefore, if anyone says that prior thereto you had drafted an indictment, that would not be correct. Well, as the prosecution team, Advocate Maema, the prosecution team, remember, the indictment is progressive. So we concluded drafting it, yes, towards the end of June. Advocate Mtsweni, yes. Advocate Maema, 2012. Advocate Mtsweni, but before the end of June, there was no indictment that was ready to be signed. The answer from Advocate Maema was yes, yes. Now, which indictment did you send to? Because according to which you sent to Advocate Mlocha, because according to Advocate Mlocha's testimony, I'm sorry, I beg your pardon. According to Advocate Maema's testimony, as at the 12th of June, there was no indictment yet.
Madam Chair, I need to object. My learned friend must read 46 and 47.
6 and 47 of
The transcript, Madam Chair, that he stopped reading. If he's going to suggest to the witness that as of the 12th of June, there was no draft indictment, he must read 47 and 46 and 47 and 48 of that cross-examination.
We do not have the benefit of our transcripts here right now, but we will rely on what you read, on what you have, Advocate Mushamonyane.
My learned colleague says say I should read also 47 and say 47 and 48.
Yes, I'm just asking my learned friend to continue what he was doing, but through 46, 47, 48, 49, because this issue of the 12th of June was exhaustively canvassed with Advocate Mayem.
Perhaps you can look at the transcript, the 20th of February 2026, that you said you are reading from, and you referred us to page 45 of 194. Are you suggesting he must continue to page 46, 47, 48?
Madam Chair, it actually ends at 49. So I thought he was going to read through all of them and then he stopped somewhere, which might not create a correct picture. But I don't want to make accusations at this stage. But he must just continue the line he had started.
Would you like to pause a bit, Advocate Mushamonyane, and read pages 46, 47, 48, 49? If you consider that to be helpful, you can read it into the record so that we can also follow.
I'm comfortable to do that, Madam Chair. I ended at page, must be 47, where Advocate Mayema said, yes, yes. I'm continuing. Advocate Mtsweni says, now I'm asking this because if we turn back to Advocate Chauke's affidavit, he said, quote, on the 12th June 2012, I received a draft indictment with summaries of the matters from the prosecution team. I forwarded same to Mlochwa through my PA, unquote. And the question was, do you see that? Advocate Mayema, where? Advocate Mtsweni, paragraph 75. Advocate Mayema, 75. Yes, it talks about a draft indictment. Advocate Mtsweni, yes. But you just told us that you had not finalized the indictment at that point in time. Advocate Mayema, it was, well, if there would be an indictment, it would be unfinalized and it would be a draft indictment. Advocate Mtsweni, but then let us go and see and hear what Advocate Chauke says. Advocate Mayema, okay. Advocate Mtsweni, he says, on the 14th June 2012, I attended the meeting at VGM NPA office with NDPP. In that meeting, arrangements were made that Mayema will sign the indictment, unquote. Advocate Mayema, I see that, Chairperson. Advocate Mtsweni, yes. Now, meaning that the indictment, in his view, was ready to be signed. Advocate Mayema, no, it does not mean that. Advocate Mtsweni, yes, but then let us go on. Are you aware that he sent the same indictment to Advocate Mlochwa, asking Advocate Mlochwa to sign the indictment? Advocate Mayema, I became aware here in the Enquiry. Advocate Mtsweni, yes. Advocate Mayema, and I also heard the exchange during that was referred to in the state capture. Advocate Mtsweni, and that was despite you, the prosecution team, not having finalized that indictment. And the chairperson interceded there and said, sorry, before you answer, let me understand. Are you pegging that question on paragraph 76? Advocate Mtsweni, yes. It follows that to say, well, he says he received the indictment on the 12th, and then on the 14th, he was making arrangements for that, for Advocate Mayema to sign the indictment with Advocate Jiba. Now, I'm saying to Advocate Mayema that on his version, they had not yet finalized the indictment, and yet Advocate Chauke is already making arrangements for the indictment to be signed. Chairperson. But should you not have regard to paragraph 75, where he says, that is Advocate Chauke. He received the draft indictment? Advocate Mtsweni, yes. Chairperson, yes. Advocate Mtsweni now intervenes. Chairperson, on 12 June, Advocate Mtsweni. That is correct, Madam Chair. Chairperson, yes. So what is the point that you are making? I just want to understand clearly what our point is. Advocate Mtsweni, that document being a draft, and according to Advocate Mayama, it not being a final document, Advocate Chauke was already making arrangements for it to be signed. It appears to be ending there. This must be page 49. I'm not sure whether I read the whole thing that my learned friend has referred to, but I'm unable to read it.
No. I don't want necessarily. The only point is I was objecting to the question that Advocate Mayama's evidence is that there was no draft indictment on the 12th of June. That's the only objection.
Why? So, Advocate Chauke, that
Let's deal with the objection. You hear what the objection is. Do you wish to respond to what Advocate Nkabinde is saying after reading those pages? Because we have to make a ruling on the objection.
if can I respond, Madam Chair?
Yes, sir.
If there was a draft indictment, I would concede, I would accept it.
Are you suggesting there was none?
I'm not.
So as at the time when Advocate Mayama testified, there was a draft indictment, according to you?
Yeah, if what we read here, that an indictment being a progressive process, I will then accept that there was a draft.
Meaning what you were putting to the witness was incorrect?
Not necessarily, Madam Chair. Not necessarily incorrect. Because he says he sent an indictment.
Yes.
But if it is a draft, I'll accept it is a draft. And then I'll proceed with my questions, further questions.
Well, the email B00578 simply says indictment, which was sent by Ms. Shuping, as opposed to the instance of Mr. Chauke to Advocate Molotwa.
Yes,
Yes.
yes.
And Advocate Chauke speaks of the events of the 14th of June, 2 days later. Is my reading correct?
Yes, Madam Chair.
At that meeting, it appears an intimation was made that, or an arrangement was made that Mr. Mayama will sign the indictment.
On the 14th,
At the
according to
meeting,
of the
yes.
14th
This
June
is what was made, said at the meeting of the 14th of June,
2012.
2012. Is it unreasonable to assume that that which is mentioned at B00578 in that email might have been a draft?
It is not, Madam Chair. It is
Yes.
not unreasonable. May I proceed with my questions?
You see, we are dealing with the objection, so I think Advocate Mtsweni, if you can maybe give him a chance to listen first so that we deal with this issue. We cannot leave the objection hanging. And when we are done with it, then you can confer with him. Yes, thank you. Yes, thank you. The objection is sustained pertaining to this issue about the indictment mentioned in the email communication to Mr. Mlocho and the subsequent testimony by Advocate Maema relating to the meeting of the 14th of June 2012. Meaning that that which was mentioned at the meeting of the 14th of June 2012 related to an indictment that had to be signed by Mr. Maema according to the arrangement. But that which was sent on the 12th of June 2012, 2 days prior, can reasonably be understood to have been a draft indictment that was sent at the instance of Mr. Advocate Chauke to Advocate Mlocho. Accordingly, as I mentioned, the objection is sustained.
Thank you, Madam Chair, as it pleases. Thank you, the Chair.
You may confer with your brother.
Thank you, Madam Chair. Thank you, Madam Chair. May I proceed? So, Advocate Chauke, we may accept that the document that you sent to Advocate Mlocho on the 12th June 2012 through your personal assistant, Mamiki Suping, was a draft indictment, not so?
Yes.
Do you sign draft indictments? Why must Mlocho sign a draft indictment, which was not final, not so? It was
Yes.
not final.
Yes.
Why must Mlocho sign a draft indictment?
For him to be appraised with the matter.
To be?
Appraised with the matter.
What is the purpose of signing an indictment, whether it be a draft or a final one? What is the purpose?
The purpose when you are in court is to place the accused before the court.
So had Advocate Mlocho signed that document, it would have served before the High Court
It would have been served before the regional court.
or before the regional court.
Yes.
Okay. Now, I want to refer you to a document which I take was an indictment. And you should confirm whether it was the same document that you sent to Advocate Mlocho. You will find it in B2, bundle B2, from page B00484. Madam Chair. It starts from 484. Advocate Nkabinde, I don't mean to take you back, but you said something about Advocate Mlocho signing an indictment. And from the reading of paragraph 118, 6-33, Advocate Chauke says
his PA emailed the draft cover letter to acting KZN DPP Advocate Mlojwa, and we now know that the draft cover letter refers to the indictment. That's what he admitted to.
Yes, Madam.
But I don't see. Okay. Well, I'm reading now the second paragraph that says a disagreement subsequently arose regarding the sufficiency of the documentation, with Advocate Mlojwa refusing to sign. But also go back to the transcript, because as Advocate Mtsweni, while cross-examining Advocate Maema, there was an objection raised by Advocate Nkabinde. I think on page 49, the last sentence there. And it had something to do with the question whether Advocate Chauke instructed Mr. Mlojwa to sign the indictment. Not sure if you saw that while you were reading. That would be, it's the last sentence at page 49 and goes to the first two lines on page 50. And unfortunately, we only have extract, so I do not know what was the final decision on that objection. And I wouldn't want us to deal with an issue where an objection was raised and there was a pronouncement and we repeat the issue. If you can look past page 50, because I only have up to page 50, where Advocate Mtsweni was, where the chairperson asked, that is why I asked you, who made the arrangements that Advocate Maema will sign the indictment, right? And then Advocate Mtsweni refers to the same paragraph of the 14th of June 2012, but I only have three lines. That is, we only have up to page 50. If you can go up to page 51 and see how that objection, okay, thank you,
How it was dealt with.
how it was dealt with, so that we do not have something that was objected to repeated into the record. Thank you.
Yeah, on page 50, starting from page 49, where Advocate Gugatobi SC said, Madam Chair, could I just ask my learned friend to point us to the page where Mr. Chauke instructs Mr. Mlojwa to sign the indictment? And then says Chairperson, yes, I'm on that point because I'm lost. That is why I'm asking counsel to assist me. From when you read from paragraph 75, that is why I took counsel there. Advocate Chauke says, quote, on 12 June 2012, I received the draft indictment with summaries. I forwarded same to Mlojwa through my PA. And then it's written 76. On 14 June 2012, I, Advocate Chauke, attended a meeting at VGM head office. In that meeting, it is Advocate Chauke speaking. It's written Chaukas there, but I think it's a misspelling. Advocate Chauke speaking. Arrangements were made that Maema will sign an indictment. That is why I asked you, who made the arrangements that Advocate Maema will sign the indictment? Advocate Mtsweni, Madam Chair, he tells us in his affidavit that he attended a meeting. If one reads, I just want to get to the document again. He says at paragraph 76, quote, on 14 June 2012, I attended a meeting at VGM NPA head office with NDPP. In that meeting, arrangements were made that Maema will sign the indictment, unquote. So, meaning that the arrangement was being made between him and the NDPP. Chairperson, indistinct, microphone off. Advocate Mtsweni. Advocate Chauke, because he said he attended, he does not tell us that there was anyone in that meeting. It was him and the NDPP, because he says, I attended a meeting at VGM NPA head office with NDPP, and he does not tell us that there was anyone else. Yes. Chairperson says yes. Advocate Mtsweni, and then he says, at that meeting, arrangements were made that Maema will sign the indictment. Chairperson, yes. Advocate Mtsweni, yes. Chairperson, yes. What was your question, Advocate Mtsweni? And the point is that the prosecution team had not finalized the indictment, and yet Advocate Chauke is already making arrangements with the NDPP that Maema will sign. I will pause there, Madam Baloi Mere, SC, and you may indicate as to whether it's enough to the extent to which I've read.
I'd like to go further because at page 52, Advocate Mtsweni then went on and said, because the objection was not dealt with, Advocate Nkabinde still persisted with the objection, and Advocate Mtsweni then retracted the question. Oh, sorry, I'll repeat. My microphone was not on. I'm saying, if you proceed to read the text that you were reading, when you go to page 52, because the objection was not ruled on, Advocate Nkabinde persisted with his objection. And then Advocate Mtsweni's response was, no, Madam Chair, I retract the question. It was a mistake. I should not have said that. And then he went on and said, I retract that question and that statement. I did not mean to put it that way. I just wanted to say he forwarded the indictment to Advocate Mlojwa. The issue here was that it seemed like Advocate Mtsweni wanted to pursue a line that Advocate Chauke sent the indictment and said to Mlojwa, sign the indictment. But when he retracted, he left his statement at, I just wanted to say the indictment was forwarded to Advocate Mlojwa, and he left it there. Sorry. That is why when I started, I said I do not want us to deal with an issue where an objection was raised and an objection was ruled on. In this instance, it was not ruled on, but Advocate Mtsweni retracted his statement and rephrased his statement so that we do not go back and forth on the same statement that was then reformulated. Thank you. Thank you, Chair.
Thank you, Madam Chair. Do you allow me to proceed?
Yes, maybe, perhaps, when you look at the retraction by Advocate Mtsweni, then, as my sister has just mentioned, we have gone back to the point. It will probably help you if you go to the emails.
That's where I wanted to go. Thank you, Madam Chair.
I have to go there with you.
Please do so. and refer you to
To keep record of what was being read to us. The records that we were given, it's up to page 50 only. And fortunately, my dear sister does have a further record of that day. It'll help if Advocate Monyani were just to tell us as to up to which page and paragraph did he read or line. At least we'll have that on record and proceed as you are doing, Chair. Please.
Thank you, Madam Ramahaha. My colleague will help me here. I'm not even sure. What page
Yes.
is it?
Page and line, up to which page and line of the transcript?
I read up to page 52, Madam Ramahaha.
Page 50.
And let me just find out as to where did no, in fact, it was 51. Can you help me out? I think it was 51. I made a mistake. Yes.
I went to page 50.
Yes. Yes. What line, if you can assist? Don't see lines here.
From line 9.
Thank you, Madam Baloi Mary, for rescuing me.
Thank you very much. Through you, Chair, it'll help, especially if what we don't have is being read out, that we just be given the information so that we record at our own time, we can read it. Thank you, Chair.
Thank you, my sister. We've gone back to that point. We've gone back to the issue of objection. What my sister was telling you, because we are not here when Advocate Mchemi was cross-examining Mr. Maema, he retracted the questions
I've seen the retraction, Madam
and
Chair.
we accepted the retraction. I was saying earlier to you that the retraction by Advocate Mchemi is consistent with the record when you look at the emails. So I was going to take you to those emails. If you look at the chronology or the sequence of those emails from page B00578, which Advocate Nkabinde dealt with, you'll see in those emails, the first one is the one at B00578, where Ms. Mamiki Suping sent an indictment.
I see that, Madam Chair.
The evidence is that that covering letter contained there was a covering letter of the documents which included the indictment. You accepted earlier that we can reasonably assume that it was a draft indictment. This is on the 12th of June, 2012. When these documents were signed, sent to Mr. Mlojo. Now, there is no way where Advocate Chauke or the email of Mamiki Supin says, sign the indictment. There is no way. Now look at the subsequent email by Mr. Mlojo himself, the same day at 3:21 p.m.
The one on page B00577.
Yes. The bottom of that document
I'm there, Madam Chair.
up to the next page. You want to read it?
I think it's already on record, Madam Chair. Not necessary to read it, but
I
if
just
you
wanted to close this
close it,
line of questioning because then we have to close it. We all ruled over it, but it is clear that that which was discussed at VGM on the 14th, where arrangements were made on the 14th of June that Mr. Maema will sign the indictment, was subsequent to this exchange.
yes, Madam Chair.
You see now the third email on the same day by Mr. Mlojo.
Yes, The one at the bottom, the one written
No,
in,
no. The first one was the first one on B00578. You see that first email?
from Mamiki Suping.
Yes.
I see it. That,
On the 12th of June. Look at the time there. It's
29.
1:29. The response from Mr. Mlojo was at same day at 3:21. On the same day, Mr. Chauke writes to Mr. Mlojo. You see the third one?
I see it, Madam
You see
Chair.
the third one?
Yes, I see it.
From this communication, there is no way where a suggestion was made that Mr. Mlojo must sign.
Will you allow me to respond after you shall have?
I'm asking you whether, is there anywhere in this communication where Mr. Mlojo was told to sign?
May I take Madam Chair and the panel to the third communication by Advocate Chauke and refer you to the last but one paragraph.
Yes,
If you permit me, I can read it into the record.
you may read it, Shura.
It says, and I quote, it came at 5:14. He was responding to the one that from Advocate Molocha that came in at 3:21 p.m. And Advocate Chauke at 5:14 p.m. says, among others, the following, and I quote, another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest in view of the fact that you have been requested to sign the document, which must be preceded by a decision to reopen the inquest. I'll leave it at that, unquote. It would appear from what Advocate Chauke is saying here, Advocate Mlocha was required to sign the document, the indictment.
Do you read that from the first email by Mamiki? Because that's when documents were sent to him for the first time. And Advocate Molocha then responds and says, give me a memo or report. You see that?
Yes, I see that, Madam Chair.
The third email must be read in the context of the second email. You can't read that in isolation. You see the second email at the bottom of B00577. There was an exchange there. Mr. Mlojo responds to Mr. Chauke, where he says, can't you furnish me with the prosecutor's memo or report so that I can have a wraparound views of the matter? The report must also have the police station and case numbers so that we can open up the DPP's file. Then it is that long email by Mr. Maema. I see the point that you are addressing. After this third email, you had just asked the witness about the arrangements made on the 14th of June at VGM, where Mr. Maema arrangement was made that Mr. Maema was asked to sign the indictment. That's where you ended before the interruption by my sister.
Yes, and there's a point, if you allow me, Madam Chair, on the second, the responding email of Advocate Molocha on page 00577B005, where in paragraph 1, it would appear that he had had a conversation, a telephone conversation with Mr. Advocate Chauke. I just wanted to place that on record. He has responded through before he wrote this email. But be that as it may I proceed with my next
Sorry,
question?
Madam Chair, I really hate objecting when counsel is cross-examining. But it has to be clear what point is being made here. The original point made by Mr. Mtweni was that Advocate Chauke instructed Advocate Molocha to sign the indictment. Is that the same point that is being made by my learned friend now? And if so, I would ask that he shows us where the instruction from Mr. Chauke to Mr. Mlocha to sign the indictment appears.
Are you persisting with the point, Council?
Madam Chair, I'm not persisting with the point that there was an instruction to sign because it was retracted. The point I'm persisting with is the one that appears in the paragraph that I have read, that you were requested to sign.
Yes.
That is the point, which is a version of Advocate Chauke.
Yes. Advocate Chauke may address that point in your letter of the 12th June at 5:14. The third email of that day. It is B3, Voices 3 of 11, at page B00577. You remember I mentioned that there were 3 emails on that day. The first one was by Manuki Suping at page 00578. It was followed by the response by Mr. Mlojo at 3:21. That signals that after receiving these documents, he communicated with you. You had a telephonic discussion. And then after that email, that is after 3:21, at about 5:14, same day, you wrote to Mr. Mlojo. At paragraph, the last but one paragraph, you made mention that he had been requested to sign the indictment. You can address that point.
To address, what is the comment? May I make comments or what?
Yes.
What is the question?
The content of that last but one paragraph.
It's correct that I wrote that email to Advocate Mlosh.
I'm referring you, Advocate Chauke. Counsel, I'm referring you to the last but one paragraph of your email, the third one, the one at B00577. You have that
Yes.
long email.
Yes.
Look at the last but one paragraph.
Yes, I see that I said I requested, he has been requested to sign the indictment.
Yes, he's dealing with that aspect that Mr. Mlojo was asked to sign that draft indictment, correct? Mr. Mlonyane?
Correct, Madam Chair.
So I'm asking you to deal with this aspect.
Maybe I'm misunderstanding the question. It's correct that I wrote and conveyed to Mr. Mlocha that he should sign the direct indictment before the inquest can be reopened.
Yes. The point that was made earlier was that how could Mr. Mlojo be expected to sign a draft indictment? You remember the indictment that was sent to him of the 12th of June, which was sent by Ms. Suping,
Yes.
was a draft. And the point was made that how could he be expected to sign an indictment which was a draft? And you answer that he had to familiarize himself with what was contained in the indictment.
Yes.
It emerges now that in your email to him, after your communication, your telephonic conversation with him,
Yes.
you then wrote what you wrote at that last but one paragraph.
Yes.
Meaning, if I understand your answer, you expected him to sign a draft indictment.
Yes.
Now, his question earlier on was how could he be expected to sign a draft indictment? Am I correct?
Chair.
Yes, thank you. Are you able to answer that?
Yes. That's why I indicated that the draft for him to sign it will lay the basis for him to be able to reopen make application to reopen the.
May I proceed, Madam Chair?
Proceed.
Earlier on, I said, I want to refer you to a document which apparently is that draft indictment, but you will confirm whether it is the one that you sent to Advocate Molocho. Let me direct your attention to the index to folder B, poison, to the index number 32, which shows draft indictment at B00484. It says undated draft indictment, and then the page it gives us B00484 up to and including B00529.
Are you referring to the index of Boyson's 3? Because there's
It's
Boyson's 1, 2, 3, up to 11.
B2, Madam Chair.
B2.
Yeah, B2, bundle B2. It's numbers.
Yes, I'm at 00484 now.
On the doc,
Yes, I'm at 00484 now.
on the document itself, or are you on the index? I'm referring first to the index. Let's start there.
Which page is the index?
Maybe perhaps it's page 3 of the index. And item 32.
Please assist there and give the witness the document and show him the number. It's number 32 at page 3.
Yes, I see that, Chair.
Yes. And it is 32 undated, draft indictment B00484 to B00529. Is that what you are referring the witness to?
Indeed, itself, 484.
Yes,
Are you there?
yes,
Fine. You see there, it's a document that reads in the High Court of South Africa, in brackets underneath there, Peter Marisbeck.
yes.
It says, it reads as follows, and I'll read only the top portion. It says, the Director of Public Prosecutions for the South Gauteng High Court, Johannesburg, who prosecutes for and on behalf of the state, hereby informs the Honorable Court that, colon, and the names of the accused there. The first one is Mr. Paul, and their ages are not mentioned there. And then it goes on. So this is an indictment, not so. Go to page 2, the next page, 485.
It is a draft indictment.
Yes, getting there, Madam Chair. It's my apologies. It's a draft indictment.
Yes.
Okay. Go to the last page, Advocate Chaute. 521. It's B00521.
Yes.
That document there, it's in your name.
Yes.
Can you explain that? The reason why it is in your name as the DPP South Gauteng.
It was drafted by the prosecution team, Advocate M.
Not yourself.
No, sir.
Is this the draft indictment that was, which you requested Advocate Molocha to sign?
No.
Is this one?
No.
Oh, it's not this one.
No.
It's another one,
Yes.
similar to this one.
Yes.
Okay.
That will be in the name of Advocate Mloto, not in the name of Chauke.
Which one?
The one that would have been sent to Mloto.
I see. But maybe I'm confused. Just help me out here. You are the DPP in Gauteng, in South Gauteng.
Yes.
A matter is supposed to be prosecuted in KZN,
Yes.
but a draft is done in the name of South Gauteng.
Yes.
Why should that be?
Advocate Maema was here before the panel. He explained that he was doing the draft cut and paste. He explained, was he?
Yeah, maybe he might have explained, but
Yes.
I ask you to explain to me.
I can't explain to you something that I did not draft.
See, the difficulty with this Advocate Moshamonyane is that you were not here when Advocate Maema testified and when he was cross-examined by Mr. Mchweni. If you go back to the transcript, I hope you had an opportunity to read the transcript. This aspect was dealt with by Mr. Maema, and he explained all that as to why Mr. Chauke, first of all, his office was used, and then they drafted document, and he signed some of the documents to send them to the NDPP. So probably you'd have to ask your colleague to take you to the transcript and familiarize yourself with what Advocate Maema's evidence was, because we don't want to go back to that evidence and then rehash what he said. I do accept that you don't have the benefit of his evidence because you were not here. But if you say to me you have read the transcript to familiarize yourself with the evidence, I will accept that.
Madam Chair, I will accept that we should not rehash. Allow me to proceed. We should not rehash the evidence that has been.
Have you read the transcript?
Not that part. I didn't have time to read that part. And if it has been dealt with extensively, I will pack it and proceed with other matters, other issues.
Yes, but what helps is that when you are not here, when a particular witness led evidence and you'd like to ask questions pertaining to that witness, whose evidence you have not had, for you to read that.
That is why I say I'll accept. And there's just no time to go to the record now, and because it's going to take time. We're going to waste time, the panel's time. I'm amenable to proceed with other questions and leave this issue that has been extensively dealt with.
I'm not stopping your cross-examination. I'm saying to you, and I don't want you to just abandon the point because it may well be a very important point. I'm simply advising that familiarize yourself with the transcription, the contents of the transcript, before you proceed, so that you know precisely what transpired during your absence, so that you don't go back and forth and try to tell you what happened because your colleague was sitting here alone and you are now cross-examining a witness about something that you didn't even, you're not even here when this particular evidence was there. And it's taking us back to the transcript. And you can see now they are bringing our files from the office because we did not anticipate these questions. And I'm advising you again, but read the transcript before we proceed so that you know what happened when you're not here. You may proceed, sir.
Madam Chair, in that event, I will ask for a short adjournment to go and familiarize myself with that portion of the transcript.
No, I think you can park this question so that we can make progress. We will note it. I wouldn't just like you to abandon it. And tomorrow when you proceed, you can go back to this aspect because you would have read the transcript.
Yes, it pleases you, Madam Chair. I'm advised by Advocate Mutshwane that it may be lunch break. I don't know what time was arranged so for lunch recess.
I don't know. Advocate Mutshwane, I have to confer with my colleagues. I even forgot that there is things called lunch. Just a minute. Yes, thank you, Madam Chair. It's indeed lunchtime. We've gone beyond lunch. We have gone beyond lunchtime. We will adjourn now, Advocate Chauke. We'll pause from now. It's about 1:45. We'll take a 45 minutes lunch break.
Thank you, Chair.
We will adjourn until 2:30.
decisions that exonerated the police who fired shots or who killed those victims. Those decisions, are they judicial decisions?
Yes.
Which are contained on a document called the